because you're considering the knowledge of the officer, not generally accepted police practices. They may coincide from time to time, but you're looking at what, he's a street cop. He's trained. Hours and hours of training. You saw a lot about taser training. Why are you seeing this? Because this is what's in his head. What happens when you get hit with a taser? I mean, is there any doubt that the training puts the fear of God in these guys about these tasers? They're weapons. Heard about firearms training, deadly force scenarios. One of you asked if they have implicit bias training. They do. This is a heavily trained department. And what is the point of all this training? Let me tell you about training. Officers are put in situations like this all the time. And you train because when you don't have time to make a reasoned decision with all the facts about everybody, you rely on your training. So when the time comes, you have to make a decision, you can act quickly. The same thing in military drills, sports. If you ever played sports, what do? You practice. So it comes almost automatic. When you don't have time to think in stressful situations, you rely on your training. All right, Captain Cyber, he's a training officer, expert on GRPD policy and training. He testified that officers sure trained on GRPD policies and trainings, not generally accepted police practices. Follow GRPD policy and training in the situation. Once a decision was made to use deadly force, he's not required to try other options. It's the decision to use deadly force. A reasonable officer in this situation could have used deadly force. Mr. Becker, question. The Captain Cyber didn't do an expert report. This does not matter at all. It's irrelevant whether or not he did an expert report. He was paid exactly $0. I know you heard a lot of paid experts. Captain Cyber isn't one of them. Captain McCursey. He's an expert in GRPD training and tasers. What did he tell you? Officer Sure was given warnings that taser is a dangerous weapon. If someone gets your weapon, assume they're going to use it against you. A taser can incapacitate you, probe or drive stun. An officer does not have to wait before being harmed or killed before resorting to deadly force. And a reasonable GRPD officer in this situation could have used deadly force. He followed his training. The captains in the GRPD believe that he was reasonable in this situation. Now, let's talk about the prosecutors' experts on GRPD training. Here they are. None. So everything that involves his knowledge, you heard from the defense, and nothing from the prosecution. How did they show you he didn't follow his training? They didn't call a single GRPD officer. You know why he didn't call one? It's his burden to put on proof. Ask that question yourself. How else does the prosecution fail to meet its burden? We heard about exhaustion. Heard from Lombartel. It's reasonable for an officer in Sure's position to lose ability to continue fighting. In a fight, you lose ability to contract muscles within 30 seconds. He was in a position of tactical disadvantage, not advantage. He fought with him for 2.5 minutes with a man that was larger than him. He's got nothing less, and he lost control of his taser. Or from Dr. Kroll, he wins the award for the smartest witness, the biomedical scientist. Why are we calling him? Because we're trying to refute this testimony by Professor Stoughton, who is not a taser expert, that you can't be incapacitated by this thing. So if you think that Professor Stoughton actually knows more than Mr. Childs, we called another expert. Drive stun can temporarily incapacitate you through disorientation. You have the probes, and then you have the drive stun. A scientist came and told you, yes, you could be temporarily incapacitated. And Professor Stoughton agrees, if you can be incapacitated and you're in fear of incapacitation, you can use deadly force. The drive stun can and has caused great bodily harm to sensitive areas. You heard this whole thing from Professor Stoughton. There's no reported deaths of police officers who lost their tasers as officers trained after they lost their tasers where someone took their gun and killed them. And you know why? You also heard that answer from Dr. Kroll. Because officers are trained to use deadly force if someone gets your taser. That's why. He told you how many deaths there were. You heard from Dave Blake. Well, you first heard from Mr. Bloomfield that this is not the type of situation where auditory exclusion and tunnel vision or this sort of closing in, it's not stressful enough. And then I usually ask, are you an expert in human factors? Well, no. So this is Dave Blake. He is. He said this is exactly the type of case where this could occur. And that Chris did not have time to give a warning. That's it. That's how much time he's got to make up his mind. That's what you're judging him on. And that decision, not whether he chased him a minute and a half before, that's how much time he's got to decide and whether that was reasonable under those circumstances. The prosecution suggests that you shouldn't credit Dr. Blake's testimony because he went to an online school. But yet, he wants you to credit Mr. Bloomfield's testimony, even though he didn't go to school for this. I'll let you decide who's more credible. So you heard from the use of force experts. They pretty much agree on a lot of stuff. We agree on the standard as trained. When you're in fear of great bodily harm or death, that means you're not worried about a paper cut. It's got to be like stabbing, breaking a bone, or losing an eye. And of course, death. Then if the prosecutor could show beyond a reasonable doubt that he wasn't in fear at that moment, that's the standard. You heard about the totality of circumstances. And you can go through these. These are the things you're supposed to consider when reviewing whether or not the decision to use deadly force was appropriate. And we agree that a lot of these things apply. But that doesn't mean he shouldn't have tried to arrest him in the first place. This just means, under the totality of circumstances, the decision to use deadly force was reasonable. You know what's not on there? Foot chases. Because it doesn't matter. It's the decision to use deadly force that you have to consider. And he was bigger than him. There were multiple people. He was stronger than him. He got his taser. He's in a bad tactical position, or if you believe Professor Stoughton, he's in a better tactical position. The fitness level, the exhaustion, it's raining. He's getting up with the taser in his hand, and he's right next to him. All these factors point to a positive decision to use deadly force. You heard from Officer Gady. He's a firearms instructor. It's deadly force is deadly force. All the experts agree on this. It's the decision to use deadly force that you're judging, not the location of the shot. Not one expert said, oh, you have to try to wing him or hit him in the hand or hit him in the side. That is not what these experts are saying. It's the decision. Am I in fear of imminent threat? Is there an imminent threat? Then I can use deadly force. The manner of deadly force doesn't matter, and everybody agrees to that. Where do they disagree? Well, you heard that the prosecutor's taser expert and the prosecutor's use of force experts disagree. And you also heard that their use of force experts didn't really rely on GRPD policies and Michigan law. Instead, they have this generally accepted police practices. And that's because Professor Stoughton and Mr. Bloomfield, they're viewing this in hindsight, and everybody agrees you shouldn't do that. It's a sort of a woulda, coulda, shoulda thing. If you go back in the jury room and say, you know, if he just had let him go, that is not the proper analysis. I wish he just, I guarantee Christopher sure wishes in hindsight that he had let him go. He didn't want to make this decision. That's exactly what the prosecution is doing here. Monday morning quarterback, based on all kinds of issues that don't matter. It's the moment of the threat. Look at his training, his knowledge, what he knew. And you take that into that situation and you decide that based on what was in his head, the decision to use deadly force was reasonable. In this case, they have to prove beyond a reasonable doubt that it was unreasonable. Now you heard Chris testify. He had no obligation to testify. It's a criminal case. What did he tell you? He testified about his knowledge, his training, and experience. He was exhausted, running on fumes. He was alone. He called it in right away, but there's nobody there. You can listen to the video. Do you hear any sirens at the moment of the threat? Listen to it. Crickets. Where is everybody? He testified he did everything he could to avoid using deadly force. He didn't pull out his gun as soon as he grabbed the taser. Probably could have under this training. What are you trying to get it back? And he's screaming at the guy, let go of the taser. It's the moment of the threat. He testified that he saw the firearm. Let's get that. In his hand. He was trying to he testified he tried to put the safety on. Couldn't do it. He's in a bad position. He does not feel like he's safe. He's pulling himself up again. And look at what Mr. Lloyd had done 3 times prior. Literally lifted him off the ground. And now this time he's got the taser. It's reasonable for an officer to think in that situation that he's going to use it on him. It would be unreasonable for him to think he wasn't. But when he's given a chance, he comes into the stand to cross-examine him as vigorously as he did Captain Cyber. He barely even asked him about the moment of the threat. What does he ask him about? You didn't have to chase him, right? That's the questions they got. You stand too close to him. You're in really good shape, aren't you? That's just designed to mislead you from the issue that is why you're here. He suggests that he's lying about the second pop because he said, look at the statement. Did he ask him about hearing it? Nope. He just wants you to look at a statement that was done. As Christopher Sure testified, I kind of wrote it like a police report after seeing the video. I mean, this video was out there right away. That wasn't his fault. And then you have the state police asking for a statement. He's got counsel already. And he signed it, so it's attributable to him. But keep that in mind. View the actual evidence, the testimony. The prosecutor has a chance to ask him all these questions. Now he asks you to answer based solely on a statement that was written with the help of lawyers a few weeks after the incident. That's not fair. He didn't have to testify, he did, and then he didn't ask him any questions. How can you assess his credibility on these issues when he wouldn't even ask the questions? All you're left with was what he said originally, but it wasn't the focus of cross-examination. No, it's something he wrote kind of like a police report because he's a police officer. And look at this exhibit right here. If you're wondering whether he's exhausted, I know he's in good shape, but 2.5 minutes trying to wrangle a grown man, desperately trying to get a taser back, is not the same thing as running on a treadmill. So you're going to hear about the law, and I think I have already stated over and over again what the issue is. Nowhere in here will it say, please consider whether or not Officer Schur's complied with policy. Nowhere in it will say, hey, maybe we should change GRPD's foot policy. Please give us your thoughts on that. No. That's a distraction. Go to the next one. The relevant consideration is not what defendants should have known or done, but rather what a reasonable officer with the knowledge and the situation of the arresting officer could have believed at the moment the officer made the decision to use deadly force. That's why we're here. Professor Stoughton and Mr. Bloomfield say it was no reasonable officer could have thought he was in fear. We don't think the prosecutors come close to meeting that burden. If you start discussing whether or not GRPD should have a foot pursuit policy, stop, because that's not relevant. Look at the moment of the decision. It's the decision. Please just look at this decision and whether or not there is enough there for any reasonable officer to think he might be in fear of harm. You're going to hear also that police officers do not have a duty to retreat. And this is important because private citizens do. Like if he wasn't a police officer and you saw this, then yeah, he put himself in a position he shouldn't be in. But Officer Schur, he's not supposed to be retreating. He doesn't have a duty to retreat because he's a police officer. He put himself in danger, yes, because that's his job. You heard from one of the officers about the cowardice policy, just letting people go. You have to be sure that he wasn't in fear of great bodily harm or death before you can convict him of murder. Now, we go to the next one, please. Honestly, or go back, I'm sorry. One more. It has to be an honest and reasonable belief. You heard from Officer Schur. Judge him on his testimony. And judge him his testimony in comparison to what you saw in evidence from the video. You heard him say that Mr. Leoya had exclusive control of the taser, and he did. You heard him say that he was completely exhausted after a minute, and you saw how he was 4 minutes after. And if there's any question whether he feared that taser, whether he had an honest belief, if he doesn't fear it, ask yourself, why is he trying to get it back? What is he, even after the second discharge? Does he stop for a second and slow down after that second probe goes? No, he's still going gangbusters trying to get it back. Why would you turn the safety on if it's as dangerous as a thumb? It doesn't matter what Professor Stoughton thinks about thumbs and tasers. It matters what he thinks. And look at the video. Does he slow down for a second? He's fighting as hard as he can to get that thing back. He's going over the top of him. He's putting himself at harm. Yes, because he's trying to get it back. Reasonable? This is what the prosecutor thinks is reasonable. No reasonable officer could have thought that that taser with the probes discharged could harm him, could incapacitate him. None, not one. These guys who didn't even talk to the taser expert for the prosecution, who disagrees with that completely. If no reasonable officer could have been in harm or thought he could be incapacitated, then why does everybody else that's called to the stand think you could, including taser experts? Especially when handled by an untrained person. Now you're going to hear a separate jury instruction on manslaughter. It's the first time you're hearing this. This is the prosecution recognizing this case is weak. It's a lesser included. It's for cases where someone didn't intend to shoot the gun. Officer, he got up there and he told you, yeah, I intended to use deadly force. I intended to shoot him. But it was justified because he had the taser and I was in fear. This is not a situation where someone gets in a fight and they don't really intend to kill him, but they lose their cool in the heat of passion before they have time to cool off. They kill someone and didn't really intend it. That's a lesser included. That's not this case. And justification of self-defense is a defense to both of them. So if you find that the prosecutor hasn't met his burden to show that he was unreasonably in fear, then you must acquit to both of them. You absolutely cannot convict him of murder or manslaughter if you acquit him of murder. Now, you heard a lot about the burden of proof. And it's important. It's a criminal case. It's not a civil case. I think a lot of you were asked during the voir dire whether, it's got to be one of the it's one of the most important decisions in your life, like buying a house. I agree. It's got to be, this decision is as important as those. And this is the highest burden under the law. I like to equate it to, you have a friend, family member who's on life support, and you have to decide whether or not to take them off life support. That's how important this decision is. It's any reasonable doubt. Now, the wiggle room in there is if it's not reasonable. If it's an unreasonable doubt, then that's not something you should consider. It has to be a reasonable doubt. If you have any sliver of reasonable doubt, then you must acquit. They have to prove beyond a reasonable doubt that he wasn't in fear and that his use of deadly force was unreasonable. If you back this thing right, he might have been justified. You must acquit. He could have been justified. Not sure whether he acted reasonably or not. That's an acquittal. That's the burden the prosecutor has to show before this is murder. And we just ask that you judge him on the decision and not all this noise around it. It's the split second. Any reasonable officer? This isn't murder. What an impossible decision. Make up your mind. It's not murder. It's not manslaughter. This man did not commit a crime. No one is saying Patrick Lillard deserved to die. That is not what this is about. It's about in the decision that we asked Christopher Scher to make in that moment where he's supposed to be, whether the prosecutor shown beyond a reasonable doubt that it was unreasonable. No reasonable officer could have used deadly force in that situation. That's the standard. And their experts don't even agree on what's dangerous. You must acquit him of both charges. Thank you.
Do you have rebuttal?
I do, Your Honor.
Okay. You may go ahead.
Agree. So you have attack prosecution's experts. That's one thing you gotta take a look at. You gotta take a look at the credibility of witnesses. This is one of the instructions you're gonna get. Does a witness have any bias, prejudice, or personal interest on how a case is decided? And that includes the experts. That includes everybody here. So you want to compare experts here, let's compare for science. For science is not an expert entity. For science is an advocacy group for police officers. That's what they're there, Bond Kliem, and that's their network. That's their whole thing. So you want to compare about why not to believe somebody. Why would you believe an entity that starts out with giving the benefit of the doubt to the officer? That was Bond Kliem's testimony. He starts out. So how can you be impartial? How can you be coming from a position of neutrality when you start out? You're going to get the benefit of the doubt to the police officer, which goes into them finding 98% of the time officers acted appropriately. What other profession is that infallible? What other profession? Name one that they're correct 98% of the time. So that goes into how do you believe they're experts? Yeah, they created a bunch of experts out here. And it gives you just an insight of what happened. Because you remember my question to Mr. Bartel. I said, well, geez, MMA goes 5 minutes, right? MMA goes 5 minutes. Well, it was the dumbest question ever made in the history of cross-examinations because the disdain from the stand just oozed out of his pores. How can you can't compare an officer to an MMA fighter? MMA fighters train for 3 hours a day, the whole years, and blah blah blah. Yet the next day, when Von Kliem, his partner, his friend, who he presents with all the time, what does Von Kliem do in his report? Compares Patrick to an MMA fighter. Because that's what they got to do. They've got to say the opportunity. He has an opportunity because he can spring up like an MMA fighter. That gives you a window in terms of the prism. They translate what happens based on an officer. They like officers, which is perfectly fine. I'm not saying that they shouldn't have advocacy groups for officers, but you judge an officer by one standard, then you judge the victim by another one. That's the opportunity. That was a tactful advantage because why? Because Von Kliem and Lon Bartel's judicially grappling. And so ergo that Patrick has the same opportunity because he can suddenly spring up from a face down or a face on his back position and maybe use the taser. That's what gives him the opportunity. Von Kliem talks about, disproportionate resistance. That's their intent. That's his interpretation. That's what he said. Well, you can determine the intent. Disproportionate resistance by Patrick is why you can think he's going to use deadly force. Von Kliem doesn't want to use that against police officers because they have no idea how can they come up with disproportionate. They can't comprehend that. So we want to talk about bias and prejudice against the experts. We want to criticize ours. Take a look at theirs, and they're comparing apples and oranges because our experts are use of force. They say in terms of taser, what a taser does, what a taser can do, and it's possible for these things to happen, but it's not reasonable to think it is going to happen. That's the reasonableness test. You can't look at every sort of possibility in the universe of what might happen and then say, oh, it's reasonable that you can do it. I mean, why does it take rebuilding? You listen to all the bad things that can happen on any of the drugs that are on TV because they may cause hair loss, liver problems, and so on and so forth. but they want to use that as justification because all this may happen. It could, the wires could. There is no, talk about distractions. There is no evidence the wires were broken. There's no evidence that anybody was feeling MNI. There's no evidence that wires had any impact. But they got to throw out all these things. You want to talk about another thing? Why isn't GRPD? Why didn't you ask for GRPD? Does a bank, when somebody invests money, investigate their own? No, they call it an independent. They call it an outside organization. How hard is it? And this is not just GRPD, this is for anybody. How do you judge something that you train? I mean, Captain Cyber said, yeah, I was his commander at one point in time. You think they're coming from a position of not bias because you're asking to judge their policies, their procedures, and what this person does? They like him. He's a good guy. How do you come in and say they're impartial? And once again, to give a window on that, what did Captain Cyber say? Because Captain Cyber, when we asked, we said, okay, you've been listed as a defense witness. Okay, what's the policy? If somebody's disarmed with a taser, do you have a policy on that? Nope. No policy. Never heard of it. Yet then he takes a stand in front of you and says, oh yeah, that's deadly force. Well, wait a second. 2 weeks ago, when the detective asked you about it, you said, no, there's nothing. But now that, as soon as somebody disarms you, oh, the weapon, that was a weapon. You never said taser specifically, but he was asked specifically about a taser and disarmament. Nope, there's no policy on that. We don't train nothing about that. But yet all of a sudden it changes. That gives you a window of why there's bias. There's a conflict of interest. That's why we have the state police in here talking about it. There's a conflict of interest to try and bring GRPD officers to judge on another GRPD shooting incident. They have every reason, just like anybody else. Just like a bank, you don't ask the people who were responsible for training what went wrong. But even that, and this is what I'm talking about, you believe all, some, or none. They say Grand Rapids policies are generally accepted police practices. They're one and the same. There's no difference. Both of them say that. So that create this there, he doesn't know what generally police practices are because he wasn't trained on them. It's just a fallacy because it's one and the same according to GRPD. The other example is that, Officer Davey. Why couldn't you talk to the officer? I got better things to do. He doesn't want to talk to an officer to give him, I'm not disputing. That's not a dispute. Yeah, when you use deadly force, that's what's trained. You use deadly force, you're going to shoot to kill. They're not going to try and shoot an arm off. They're not going to try and shoot a foot. That is, why do you want to talk to the detective about that? And so he trains, he was part of his recruit class. It's somebody in-house. You can't ask somebody in-house to be completely impartial and unbiased when you ask them to do stuff like that. But when you look at it, when you think about it, when you try and compare in terms of what's going on between these experts, compare the experts, what about Sergeant, I think it was Johnston, the first sergeant on the scene? Let's remember his testimony. Remember what he said? Did he or didn't he not sound like Seth Stoughton? Because he was worried. He said, yeah, we pulled up. I couldn't see inside that car. I didn't know what was going on in that car. I didn't know what the individual that was standing outside the car had. He could have a gun. That's what we teach. We don't know what's going on. I mean, that's the thing. He's got 3 officers at the time, all with handguns drawn. And watch the body cams. How carefully they approach that car because they don't know. That's what they're trained. So it's kind of a contradiction in terms to say that it's okay for a single officer all by himself to run after and chase and tackle somebody, which flies in the face of their policy that says don't do that you saw. That's a big difference there. How can you chase if they're treating everybody, 3 officers on scene being that careful? Why is one officer all by himself? That's okay. That's fine. And so it's not distraction. So what is the purpose of the reasonableness of the officer's actions when you're looking at the totality of the circumstances? If it's just as many times as you snap your hands, there's no totality of circumstances. It's just looking at that moment, period. And what's the purpose of the totality of circumstances? Looking how the officer got into that situation. There is no purpose. There's no totality of circumstances. Well, he was somebody had a taser, you can shoot him. And the interesting thing was because who did they say? Who did he say? Well, Professor Kroll is the one who said, "Oh yeah, they're able to use deadly force because he did that study." Professor Kroll is a taser expert. He has no idea police policies. He said that was his testimony. It was his impression. of police policies. Because they can't bond clean, the GRPD officers, nobody can say anything about what the taser policy. There is no, take a look at all the policies, they had an opportunity, take a look at the policy where it says, if you're just starting a taser, you can use it. You can shoot them. This is not there. There is no policy. It's based on the totality of the circumstance, based on everything the officer knew at the time. And what the officer knew at the time goes back to when the incident started. The whole thing, not just looking at that one brief second. And why would a reasonable officer, when there's been no aggression, there's been nothing, no punching, no kicking, no hitting, no anything, think he was going to die because somebody had his taser? That's what's not reasonable about all this. And you're right. You're right, manslaughter is going to be brought up. And it was a complete misstatement of the law to say, well, the manslaughter is not an intent to kill. That is not the law. Listen to the instruction. It is an intent to kill. The traditional manslaughter thing is when a spouse shows up and sees their spouse in bed and loses it. That's your typical manslaughter. You lose it and they want to kill them. It's not, well, they got into a fight. A manslaughter instruction is because of emotional excitement. Because of emotional excitement, somebody who's driven to kill somebody. That's what we're talking about here. It is not just, well, there's a fight you didn't need to. That's a completely different thing. Manslaughter, listen to it. And because of emotional excitement to the point a reasonable person may have acted on an impulse. And if anything, that's what their experts are talking about. That's what their experts bring up. Yeah, Professor Lake. Yeah, heuristics. Heuristics, and I said, heuristics. It's kind of, putting in layman's terms, that means jumping to conclusions. And that's it right there. He doesn't know why he's running, so he jumps to a conclusion. The defendant jumps to a conclusion. Well, there must be something worse here. There must be something worse here. I'm going to jump to the conclusion and think it's a bad thing. That reduces it to a justified excuse. It reduces it to a lesser crime. Manslaughter is a lesser crime. So if you think this fight, if you think this battle, you need to characterize it as a battle, because what it is a wrestling match. And that's in the totality of the facts and circumstances. How does somebody want to kill you when they don't do anything else before that? How do they want to kill you? What evidence do they want to kill you? You grab my taser and I'm tired. That's not enough. That is not enough to justify taking another person's life. And watch the video. Yeah, take a look at the video. Yeah, he stands up 3 times, but at the moment he goes to push himself up, the defendant shoves him back down. He shoves him back down. He's got total control over this incident. So to think that he has to kill him at that moment is just wrong. It's not reasonable. Yeah, no reasonable officer would come up with that. And why? No idea why it's so far. Where's the fight? It's not a fight. It's a wrestling match. And that's the other thing that was, interesting about. Yeah, GRPD puts the fear of God. Puts the fear of God about tasers. Yes. Watch that video. Watch the graduation video. This is the graduation video. So the fear of God, you put it's a serious weapon, but the fear of God in the mix with that you put the soundtrack to Top Gun to in the graduation video, and take a look. Get a closer look. Look at the smiles. Look at the smiles on all their faces. Yeah. Somebody going through it again. It's taking the ride. We're talking about taking the ride. Yeah, it's a serious weapon, but it's not a weapon that's going to cause death or great bodily injury. That's not putting the fear of God in there when you put it to the soundtrack of Top Gun. It's not putting the fear of God in there when you're sitting there smiling at somebody getting tased. It's something you're concerned about, sure. But this whole thing in terms of distractions, it is once again, it's amazing now, because now we're saying don't ignore the defendant's prior statement. Ignore it because it was just a police report. But we heard it on the stand, and we couldn't trust his testimony on the stand either. Why? Because, Mr. Dodge asked him, well, you've been 3 years. There's a lot going on in those 3 years. You've been through a lot of trauma. So you can't really believe his testimony by his own, attorneys asking him questions, but then you're also not supposed to pay attention to his written statement. So how do you determine what it is? That's what the statement's there for. Compare what the differences are. Take a look what it is. Take a look. Where did the bladed stance come from? Because that's what it says in his written statement. Where's the bladed stance? Because we heard what the bladed stance was by Captain Siren. Somebody may have a gun. That was a bladed stance. No testimony to that. It was in his written statement. And then I didn't ask him questions. Well, show us the bladed stance. Well, it's a different perspective. You really can't see. So, what we're trying to do is trying to build up the danger of Patrick. Trying to build him up. He had a bladed stance. It was dangerous from the get-go. Well, then if it's dangerous from the get-go, why are you chasing him? And that's part of the totality of the circumstances. You think you may have a weapon, you shouldn't be chasing them. That's what GRPD policy says. It's a bad idea to do that. And you gotta take a look at everything that led up to the decision to fire that shot. And simply getting up is not enough with the taser. He has gotten up 3 prior times and has done nothing. Has done nothing other than try and get away. But you're supposed to jump to the conclusion, using heuristics, jumping to a conclusion that he's gonna kill you. That is not reasonable. It may reduce it, maybe it's manslaughter, but it doesn't excuse it. It doesn't say, yep, go on away. You did nothing wrong here. So when you're looking at everything, yeah, it's a big decision. But a reasonable doubt, you will hear, I've talked about it before, a reasonable doubt is a fair, honest doubt. But it means you firmly convinced. Firmly convinced based on the evidence. Based on the evidence that you presented here. And when you look at this, when you look at the facts, when you look at the evidence, you should be firmly convinced that there was a homicide here, there was a murder, it was second-degree murder, it was a death caused by the defendant, he intended to kill, and there is no justification for it. Simply having a taser with nothing more does not think, well, I'm gonna die. We've had all kinds of people up here saying, yeah, we survived, we got tased numerous times, finally got tased in the head. He's still talking about it, that's about 30 seconds. And even in terms of you want to talk about reasonable, yeah, use their expert, use Professor Kroll. It's never happened in the history of policing. Where an officer's been tased, disarmed his weapon, and killed. And it's his impression that because they kill. But the one thing what he said is it's happened 9 times where a person's actually been tased, an officer's actually been tased, but in the other case, the majority of the time, nothing happens. They want to know every possibility considered. You have to consider what's reasonable. If you have a reasonable doubt that he committed a crime of homicide, that's he committed a crime of manslaughter, but he is not justified, he is not excused. Patrick is not a threat. Patrick meant no harm. Patrick wanted to get away because he was drunk or whatever. But the only logical conclusion you have is you find it guilty. Thank you.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements, arguments, and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, summary of any evidence, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think a witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You have heard that a lawyer talked to one of the witnesses. There's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard from several expert witnesses. Zachary Batchelor has given you his opinion as an expert in the field of video technician and audiovisual analysis. Dr. Stephen Cole has given you his opinion as an expert in the field of forensic pathology. Brian Childs, who has given you his opinion as an expert in the field of taser and body cam by Axon. Seth Staunton, who has given you his opinion as an expert in the field of use of force in police practices. Nicholas Bloomfield, who has given you his opinion as an expert in the field of police practices and use of force. Captain David Cyber, who has given you his opinion as an expert in the field of GRPD training policies and procedures. Captain Chad McCursey, who has given you his opinion as an expert in the field of GRPD training policies and practices regarding taser use of force and duties and functions. Lon Bartel, who has given you his opinion in the field of exercise, sports science, and exertion and exhaustion factors. Dr. Mark Kroll, who has given you his opinion in the field of operations and effects of electrical weapons. Bob McFarland, who has given you his opinion in the field of video analysis. Jason Getty, who has given you his opinion in the field of GRPD firearm training policies and practices. David Blake, who has given you his opinion in the field of human factor psychology and police practices. And Von Kliem, who has given you his opinion in the field of police practices, tactics, policy, and use of force. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they gave for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard evidence that before the trial, a witness made a statement that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. The defendant, Christopher Scher, is charged with the crime of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Patrick Lyoya. That is, that Mr. Lyoya died as a result of a gunshot wound from a gun fired by the defendant. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Mr. Lyoya, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. The prosecutor must also prove beyond a reasonable doubt the crime occurred on or about April 4th, 2022 in Kent County. You may also consider whether the defendant is guilty of the less serious crime of voluntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Patrick Lyoya, that is, that Mr. Lyoya died as a result of a gunshot wound fired from a gun by the defendant. Second, the defendant had one of these three states of mind. he intended to kill, or he intended to do great bodily harm to Mr. Leoya, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, the defendant caused the death without lawful excuse or justification. The crime of murder may be reduced to voluntary manslaughter if the defendant acted out of passion or anger brought about by adequate cause and before the defendant had reasonable time to calm down. For manslaughter, the following two things must be present. First, when the defendant acted, his thinking must be disturbed by emotional excitement to the point that a reasonable person might have acted on impulse without thinking twice from passion instead of judgment. This emotional excitement must have been the result of something that would cause a reasonable person to act rashly or on impulse. The law does not say what things are enough to do this. That is for you to decide. Second, the killing itself must result from this emotional excitement. The defendant must have acted before a reasonable time had passed to calm down and to return to reason. The law does not say how much time is needed. That is for you to decide. The test is whether a reasonable time passed under the circumstances of this case. The defendant's intent may be proven by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. You may return a verdict of guilty of the alleged crime, guilty of a less serious crime, or not guilty. The defendant claims he acted in lawful self-defense. A person has the right to use force or even take a life to defend himself under certain circumstances. If a person acts in lawful self-defense, that person's actions are justified and he is not guilty. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to him at the time he acted. At the time he acted, the defendant must have honestly and reasonably believed that he was in danger of being killed or seriously injured. If the defendant's belief was honest and reasonable, he could act immediately to defend himself, even if it turned out later he was wrong about how much danger he was in. In deciding if the defendant's belief was honest and reasonable, you should consider all the circumstances as they appeared to the defendant at the time. The relevant consideration is not what the defendant should have known or done, but rather what a reasonable officer with the knowledge and in the situation of the arresting officer could have believed at the moment the officer made the decision to use deadly force. Reasonable is that which an ordinary, prudent, and intelligent person with the knowledge and in the situation of the officer would have deemed necessary under the circumstances. A person may not kill or seriously injure another person just to protect himself against what seems like a threat of only minor injury. The defendant must have been afraid of death or serious physical injury. When you decide if the defendant was afraid of one or more of these, you should consider all the circumstances, the condition of the people involved, including their relative strength, whether the other person was armed with a dangerous weapon or had some other means of injuring the defendant, and the nature of the other person's threat. At the time he acted, the defendant must have honestly and reasonably believed that what he did was immediately necessary to prevent death or great bodily harm to himself or others. A police officer in defense of himself or others may use that force which is reasonable under the circumstances. Unlike the private citizen, a police officer, by the necessity of his duties, is not required to retreat before a display of force by his adversary. If an officer is authorized to arrest or detain someone and the person resists, the officer is entitled to use a reasonable amount of force to overcome that resistance. Like the private citizen, a police officer must reasonably believe himself to be in great danger and that his response was necessary to save himself from that danger. The defendant does not have to prove that he acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt the defendant did not act in self-defense. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. When you go to the jury room to deliberate, you may now take your notes and these full instructions. If you want to look at any or all of the exhibits that have been admitted, just ask for them. When you go to the jury room, you will be provided with written copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing to my clerk. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my clerk. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. That concludes your final instructions. We'll now pick two individuals that will be alternate jurors. So what that means is for today, you are excused. However, you still have the same restrictions as before. I'm going to ask those two individuals to leave your notes in here on the chair, and we'll make sure they're destroyed in the event that you're not needed as an alternate juror. But it's still for you, again, to maintain the restrictions as before, not access any news reports or discuss the case with anyone, because if we need to call you back as a juror, obviously if you've been out posting on Facebook about how you were a juror and all that, then you wouldn't be much use as a juror in the case. So those two individuals will still be, again, under the same restrictions, and then we will follow up and let you know when a verdict has been reached so that you know that you are discharged, whoever those two people are. And I'd also like to take this time to thank those two individuals for your time and attention for this case.
Seat number
Wait,
2,
so
120.
just because we're don't say the person's name, just say the seat number.
Seat number 2.
Yes. It's seat number 2.
Correct.
Okay. And
Seat number 1.
okay. So 1 and 2 would be you in the first 2 seats from the corner. And again, thank you very much for your time and attention, and we will let you know when a verdict has been reached so that you know that you're discharged. But if you just hang out for just another moment, then we'll send everyone back. Please raise your right hand. You do solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them, orally or otherwise, that you will not communicate with them or any of them orally or otherwise, except by the order of this court, or to ask them if they have agreed on their verdict until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they've agreed upon, so help you God.
Yes, I do.
Thank you. All right, so at this time, I'm gonna have someone come out and let you all out to go and begin deliberations. Any breaks will be on your own. If you do decide to leave for an extended period, I do ask that you have your foreperson just write a note that, hey, we're taking an hour break or however long, but that's all entirely up to you as a group. Okay.
Thank you, you may be seated.
Okay, and then I'll ask if the final instructions were satisfactory for the people
No objection, Chair.
and defense.
Although I know the objections already stated, Your Honor, they were read correctly.
Okay. And so I would just ask that you make sure that we have your contact information so that we can alert you once a verdict has been reached. I also, because I know that you didn't want to do oral argument on these motions that I received this morning after I arrived at court, but I do want to rule on them. So as far as the directed verdict, I've already ruled on that motion. It's a renewed motion. There's really not any new information contained within it, so I'm maintaining my previous ruling of denying a motion for a directed verdict. Also, there was a renewed motion for a mistrial, and part of, it's pretty much a run of the mill except for the claim of judicial bias. There's an allegation contained within the motion that I was rolling my eyes during some testimony. I can't help but believe if one of my benchmates were presiding over this trial, that exact same allegation would not have arisen. However, I obviously don't, well, maybe it's not obvious, but I'll state for the record that I don't know the defendant. I don't know the victim. This is at least my 10th, 11th, maybe 12th murder trial. I do oftentimes work on other matters while I'm up here. I have hundreds of open cases. So I don't know where that implication of bias comes from. I do note that one of the cases that were cited as support for that portion of the motion involves a case where the judge in that case inappropriately questioned the defendant, questioned the defense's witnesses. I didn't obviously question anyone except for maybe asking for some type of clarification. And so it would have to, again, in order for there to be judicial bias, it'd have to be reasonably likely that my conduct is improperly influencing the jury, and I don't believe that to be the case. Also, there was a claim that the instructions have changed over the course of the trial. I've only given instructions to the jury at the outset of the trial and at the end of the trial, and the implication is that I gave some different instructions or changed them midstream so that no one knew kind of what to expect, but I don't believe that to be the case either. I never changed instruction. It implies that different instructions were given. I was reluctant to state what the final instructions would be without any evidence being put on or presented. There weren't any interim instructions requested, so I don't believe that to be a appropriate or an argument that has any merit either. So for those reasons and the reasons I cited previously, that a mistrial, most mistrial would not be appropriate to grant, I'm going to stand by that and deny that motion as well. And if there's nothing else for the people while we go into verdict watch
Nothing pressure, Your Honor.
for defense.
Nothing, Your Honor.
All right, so again, if you do decide to leave the general area, please let us know so that we are able to get everyone back here in a decent amount of time once a verdict has been reached. Great.
Thank you, Your Honor.
We'll recess until then.